It's always with a bit of sadness that I discuss a large result, because what I'm really talking about is a person who was horribly hurt, whose life was disrupted permanently. My name is David Scher. I'm a partner at Block, O'Toole & Murphy. So this case stands out to me for a number of reasons, but the first thing that occurs to me is how much I cared for this particular client. A big result in terms of a big dollar amount means that you had a client who was very badly hurt, whose life was turned upside down. And that certainly is true for this man, who was a union steam fitter, a hard worker, a family man, married, with grown kids, a man who enjoyed activities outside of work that were very physical in nature. He was an outdoorsman. He was a hunter. He really, truly loved being in nature. And this accident robbed him of so much of that joy. The accident occurred during the construction of a new building in Manhattan. A large construction project with a general contractor and multiple subcontractors. Our client worked for one of the subcontractors doing HVAC work, installing heating and air conditioning throughout the building. The accident occurred while our client and his company were in the process of installing large pipes and attaching them to the ceiling. The pipes were attached to the ceiling with the use of hangers. And hangers are comprised of metal, and they're anchored and bolted into the ceiling, and then the pipes can just sort of run and lay along the hangers. So one particular section of pipe had been attached to the hanger. The hanger was, of course, anchored to the ceiling. And our client recognized that the pipe was uneven and had to be adjusted. So he began to climb a step ladder, an A-frame metal ladder, to get up to the pipe. And what he had planned to do was secure the pipe, which was very heavy. It weighed somewhere between 300 and 500 pounds, just this section of pipe. He planned to secure the pipe with a sling such that he could safely work on it. Well, unfortunately, as he was on his way up the ladder, before he even had a chance to touch or adjust or secure the pipe in any way, the hanger suddenly detached from the ceiling, and the pipe and hanger assembly fell down, striking our client on the head and the shoulder, knocking him violently off of the ladder, where he slammed down onto the ground. Unfortunately, our client suffered numerous bodily injuries, including to one of his shoulders, to his neck, and to his lower back. After conservative treatment failed, physical therapy, injections, diagnostic studies revealed permanent damage, discs that were badly herniated, impinging on nerve roots, multiple tears in the shoulder. And those injuries ultimately required surgeries to all three body parts, including fusions to his spine, meaning that discs had to be removed and vertebrae had to be fused together with hardware to relieve the pressure on the nerves that had been caused by the damaged discs. Our client's injuries caused him tremendous pain, numerous hospitalizations, and disabled him totally and completely from the construction work that he loved. These injuries robbed our client of so much of his identity and his sense of self-worth, so much of his joy and happiness. He loved going to work. He loved his crew. He also loved the feeling of being a productive earner who would come home and be able to provide for his family, who he also loved. These injuries took that away from our client. He no longer was able to go to work. He was no longer able to identify as a person who was a provider and an earner. All that was taken away from him, and that was extremely difficult for him. We filed suit on our client's behalf against the owner and general contractor of the project on multiple legal theories, including negligence and including a claim under a New York state law known as New York Labor Law Section 240, sometimes referred to as the Scaffold Law. We claimed that the defendants violated this law, Section 240, because they failed in two respects. They failed to properly secure the heavy pipe and prevent it from falling down into our client, and they also failed to provide a safe, elevated position for our client to work from. In this particular case, we had two bad things happen. A heavy object fell, and our client also fell. And the legal trigger for labor law section 240 applying is gravity. It's when a defendant fails to provide such protection that would prevent a gravity-related event, like a falling object or a falling worker. The defense pushed back by trying to blame our client, trying to blame our client's coworkers, and claiming that they, the powers on the site, had provided everything that they were supposed to provide. What brought the defense to the negotiating table, and in this case, literally there was a negotiating table because the case was mediated. It went to a private mediation. And in this particular case, the settlement was a result of multiple mediations, multiple sit-downs. It was a lengthy process, but one that ultimately bore great fruit. The way that our firm got the defense to come to the table in the first place with significant money to offer was by building risk in the case. What do I mean by that? That means getting through discovery, providing the defense all of the ammunition they need to huddle up and have a meeting and really appreciate the value of the case, appreciate what type of verdict we would be able to take if we did go to trial and what that would mean for them. We do that by, of course, presenting our client, presenting him for a deposition, making sure that he's able to articulate his pain and how his life has changed. We also do that by building economic damages, by hiring the best and brightest doctors and economists to be experts, and in this case, to look at our client's condition and project into the future what medical costs he'll incur as a result of these injuries, and to put a number on that with an economist and give that to the defense and say, we're going to present this to a jury. We're going to ask the jury to award this man future medical costs for X amount of dollars. Also, we're going to present, and we did present in this case, a claim for not only past but also future lost earnings and lost benefits, because this man was in a union. He had strong benefits. So providing that economic package to the defense, showing them the damages that we're going to present to a jury, putting it together in a way that is smart and cogent and powerful, brings the defense to the table. Ultimately, this case settled for $7.1 million. This settlement will allow our client to buy a nicer home to live in, to put away money for his children's future, and to make sure that any medical treatment or device or equipment that he could ever want or need to help him live with dignity, he'll be easily able to afford. The thing that this result shows about Block, O'Toole, and Murphy is that we handle construction accident labor law cases at the very highest level, and that we will never, ever compromise. On this case, we didn't accept the first offer, the second offer, the fifth offer, or the 10th offer. We didn't accept the offer at the end of the first mediation or the second mediation. We pushed and pushed until we got the absolute highest, best offer available for our client.